facilities, and I will just remind the committee that we have 2 more rules, and I do recognize that people have traveled from a distance to testify on the rights rule, which I'm not meaning to rush us. I might ask, are people able to stay over just a little bit? No, you have to leave. No. So let's try to be. Well, let's Good morning.
Good morning, ladies and gentlemen of the committee. My name is Tom Mauer. I work as an analyst for the Public Service Board, and I have been asked to appear before you today to discuss the board's temporary rule on sound levels from wind generation facilities. With me today is Kevin Fink. He's a policy analyst for the board. With the committee's permission, I would like to give a few opening remarks about the temporary rule, and then Kevin and I would be happy to answer any questions that the committee may have. The board has developed this temporary rule in response to the requirements of Section 12B of Act 174, which was signed into law on June 13th of this year. Section 12B directs the board to adopt temporary rules on sound levels for wind generation facilities using the emergency rulemaking procedures established in Section 844 of Title III for the purpose of using the existing rulemaking procedure to adopt temporary rules in a short time frame. The Act makes clear that the standard regarding imminent peril to public health, safety, or welfare shall not apply to these rules. Section 12B requires the board to adopt sound level standards applicable to wind generation facilities, as well as a methodology for determining sound levels and measurement locations for such facilities. And finally, Section 12B requires that the temporary rule shall not allow sound levels from wind generation facilities that exceed the lowest maximum decibel level that the board has previously authorized in a certificate of public good for a facility comparable size. So with those directions from Act 74, Section 12B, and the short 45 days in which the board had to adopt the temporary rule, the board began soliciting input from interested people and organizations. The board issued notice on June 14, 2016, the day after the act was signed, that the board is requesting proposals and comments for implementing the requirements of Section 12B. The board requested written proposals and comments to be submitted by June 27th, and providing an opportunity for reply comments to be filed on July 6th. The board received approximately 30 written comments in that first round, and approximately 47 written comments and proposals in the second round. After reviewing and considering all of the filings that the board received, it issued its temporary rule on July 27, 2016. As for the substance of the rule, I won't go through it line by line with the committee right now, but instead I will highlight what I believe to be the key pertinent points. First, consistent with Act 174, the board established sound level standards for 2 categories of wind generation facilities. The first category includes facilities with a plant capacity of 500 kilowatts or less, and I'll refer to that as the small wind category. The second category includes facilities with a plant capacity greater than 500 kilowatts, and we'll call that the large wind category. For the small wind category, the board established 2 sound pressure level standards. And for each wind facility in that category, the lower of the 2 sound pressure levels would be applicable. So one of the standards states that the facility shall not result in sound pressure levels in excess of 10 decibels above ambient or background levels. And using the nomenclature of acousticians, it's called the L90 sound level. The other standard states that the facility shall not result in sound pressure levels in excess of 45 decibels when measured at the exterior of a residence. So that's the small category. For the large wind category, the the board established a standard that prohibits any wind facility from causing sound pressure levels to exceed 45 decibels at the exterior of any residence and 30 decibels in interior bedrooms. The board determined that the measurement time interval for each facility in this category would be established on a case-by-case basis, but in no event would the measurement time interval exceed 1 hour. Now, for all facilities, whether they fall into the small category or the large category, the board concluded in the rule that it would evaluate the appropriate sound standards on a case-by-case basis, and then the board reserved the right to impose lower sound pressure levels as appropriate based on the evidentiary record developed in a certificate of public good proceeding. The second point I'd like to make is all petitions for a certificate of public good, except for those for really small projects, 50 kilowatts or smaller, are required to provide sound modeling as part of their application, and they're required to use conservative assumptions. The third point I'd like to make is all large wind facilities that receive a CPG will be required to pay for post-construction sound monitoring that will be conducted under the direct supervision of a state of Vermont agency designated by the board. Those are the points I'd like to highlight for the committee, and we are now happy to answer any questions that the committee may have.
Representative Buxton.
Do you assert that the rules are as stringent as the current practices?
Yes, the board believes that the standards established in the temporary rule meet the requirement of Section 12B of Act 174 that bears, which has what the board has previously adopted in certificates of public good.
In your committee has the questions that I asked the board and the answer. And I think in your answer as to the small wind facility, I think your answer suggests that that's more stringent in the sense of the upper limit of 35, because background levels could actually 10 above background could be more than 45 in a given case. Is that?
That's true.
Is that what you're?
That's true, yes. In at least one prior CPG, and maybe more, for small wind category, the board had a sound pressure level standard that said no more than 10 decibels above the L90 level. The board received comments in this temporary rule proceeding. Someone raised their hand and said, "Excuse me, board, if the background sound is 35 or greater, and the board were to apply that no more than 10 decibel standard, then in essence, you would be permitting something greater than 45 decibels, which the board has previously found in other proceedings. That should be the ceiling." So the board said, adopted, the two-part test for the small category, saying the lower of the two would be applicable. So in essence, we have the 10 decibels above L90 with a ceiling of 45 decibels, and that is more stringent than what the board has previously adopted for the small category.
I do have one more.
Yes.
This was in response to one of the questions I asked. This is about 5.708 in response to complaints. As I understand your response, and I just want to clarify it for the record of the committee, this is intended to require that certificate holders of wind projects respond to complaints raised by residents in the manner consistent with the protocol developed by the Department of Jack.
Yes, your statement is exactly consistent with the board's intent.
Okay. And the intent is not to limit residents from their statutory right to bring a case before the board, to bring a complaint to the board under Section 208 of Title 3.
That's correct.
Any further questions for Bruce with this? We do have another witness. Thank you very much. John Braden.
Hello, everyone.
Good morning.
It's still morning. So, my name is John Breven. I'm with Vermont for Community Environment. I'm the Regulatory Affairs Director.
Did we get these
I am
electronically?
going to send this to you electronically after my presentation. Happy to.
But we require things within 48 hours ahead of time, so that we cannot, I mean, we can give them to Charlene and send them to us electronically, but there's no way we can read them.
Oh, I understand. I'm going to read it to you. It's not like you're going to do
Why
a
don't you give those to Charlene?
research effort. You might want to refer to this during my testimony, however.
Okay.
Just to make it easier on you.
So this is basically a copy of your testimony?
Yeah, it's my bulleted testimony, so you can follow the bouncing ball along with me.
Because we do like to have things ahead of time so we can read them ahead of time.
I'm with you.
That's our policy.
This is just a transfer. We don't need to look at this right now. This is just for your sipping lemonade on the porch and this afternoon in the heat. I'll try to be quick because I realize that we're running late. So stop me from going too quick.
Well, it's not your fault.
Yeah, but not so much, thank you. So as I stated, my name is John Braven. I'm the Regulatory Affairs Director for Vermont for Clean Environment. And I'm here today before the Legislative Committee on Administrative Rules to address temporary rule on sound levels from wind turbine facilities that went into effect July 28th of this year. The section of the rule which concerns me and Vermont for Clean Environment and brings you to the committee today is section 5.703B, parents B, and the attorney for the PSB just defined the category this addresses. The section addresses at the large wind category, and if you're following down bullet 3, I provide a citation of the rule with a bolded section. The bolded section, I'll read to you. For the purposes of determining the interior sound pressure levels specified under this section, residences shall be presumed to have their windows open during the months of May, June, and July, August, and September. Shall be presumed to have their windows partially open during the months of October and April, and shall be presumed to have windows closed during the remaining months, which are the winter months. S260, which is a legislation which is now Act 174, governs this rulemaking process that brings us all here today, and it states a relevant part under section 12B3, and I quote, "These rules shall not allow sound levels from a wind generation facility that exceeds the lowest maximum decibel levels authorized in any certificate of public good that contains limits on decibel levels issued by the board, that's the Public Service Board, for the same category of wind generation facility before the effective date of this section." The CPG, which provides for the lowest maximum decibel levels, which is the reference standard, is that the CPG that was issued to the Kingdom Community Wind Project, also known as the Lowell Wind Project. The CPG provides a floor for establishing sound standards to be applied in the temporary rule that is before you today. This protocol requires that indoor sound monitoring be conducted with residents' bedrooms both open and closed year-round. The sum total language in these CPG sound limit protocols taken together are necessary to ensure the lowest maximum decibel sound levels are not exceeded. Removing a part of the protocol, for instance, closing the windows during the winter season, when turbines are likely running at their highest and noisiest levels, actually changes the standard. The Kingdom Community Indoor Standard is a 30 decibel LEQ level with windows open. Windows closed would be a significant deviation from the Kingdom Community Sound Monitoring Protocol, creating in effect a very different and less protective standard with resulting effect of increasing the allowable interior noise in residences in winter months and arguably in the spring and fall months as well. The effect of the application of these rule standards is inconsistent with the KCW protocol and the outcomes of this monitoring protocol. This new windows closed and partially closed standard will effectively allow sound levels from a wind generation facility that exceed lowest maximum decibel levels authorized in any certificate of public good, is therefore clearly inconsistent with legislative intent. The intent of the legislature was to ensure that the sound standards provided in the temporary sound rule would be no less protective and result in no increase in either outdoor or indoor sound levels from wind turbines during this temporary rule period. As verification of what I speak, and I'm missing the link, it's a YouTube link, but I will provide to the committee a transcript, or I have provided you a transcript of a video that's on YouTube, and it's a video of the S230 Committee of Conference that convened on the afternoon of May 6, 2016. This is important when we go to legislative intent. In this Committee of Conference discussion, Senator Bray, at 10 minutes 21 seconds, states, and I quote, "As the committee is likely aware, when the legislature convened on June 9th and passed S260, I'm sorry, that's wrong. That's typo. Here it is. You know the other thing, I think the other thing, the whole notion is to put into place a floor, so the notion of being somewhat protective. So if we remove one of the criteria that helps try to assure people that they're not going to face emissions less agreeable to them than what has already happened in current CPGs, it does seem like we are removing, and I couldn't hear the rest of it, going in the opposite direction of what we're trying to achieve through this language. What he was essentially saying is, in response to some notion that they should remove the interior sound standard altogether, Senator Brace pushed back against that and said, no, we need to maintain the current indoor sound standard that is in the most stringent CPG. Again, that is the Lowell one. Changes between S230 and S260 did not involve changes to the areas of S230 involving the directive that the PSB in its temporary rule contained indoor and outdoor sound standards no less stringent than the most stringent standards in this regard in any CPG. There is no question as to the likelihood that by closing windows, particularly where the turbines are operating at a high level and producing the highest operational sound levels, the indoor sound detected during the monitoring would be diminished. As a result, this less protective new monitoring procedure would have the resulting effect of allowing for increases in the ambient indoor noise in residences when compared to the open window sound monitoring standard, a clear violation of the express legislative intent. And I ask that you do go to this video, and you can draw your own conclusions. My statements in terms of the applicable CPG protocol to be applied are backed up by testimony provided on June 9, 2016 to the House Natural Resources Committee by Legislative Councilman Michael O'Grady. In addition to further underscoring legislative intent, I would direct the committee's attention to another video located on YouTube entitled Vermont House Natural Resources AM Veto Session Committee Meeting. And I provide a link. The video contains the House Natural Resources and Energy Committee discussion during the veto override session of Vermont Legislature held on June 9th. Contained in that video is a presentation by Alleged Counsel Michael O'Grady, which at 11 minutes 11 seconds he presents the legislative intent of the language in S230 and also the language he presented for S260. With regard to the indoor and outdoor sound monitoring standard for non-net metered industrial wind projects, those are the large ones, there was no change made in S260 to the language in S230. Attorney O'Grady states in regard to the CPG with the lowest maximum sound standard. And I quote, "So for Jen's facility, CPG would be the cap, but for the net metered facilities, the Lowell, I think, was the last, would be the cap for everything else, which is the 45-35, I think." He was then corrected by Representative Klein, who said, no, it's 45-30, and Attorney O'Grady states, yes, 45-30, and so you have the intent of capping for the different categories according to the last certificate of public good issued in those categories. The Lowell Protocol, referred to by Attorney O'Grady, is established in the final monitoring protocol, which is referenced in their CPG. Kingdom Community Wind issued April 2012, which provides in relevant part, interior measurements shall be made with windows open and closed. The methodology for calculating a single attenuation value on these measurements shall be submitted to the board, department, and affected landowners for review prior to issuance of the monitoring reports. And then it goes on to say that it's the 45 exterior and 35 DVA interior in bedrooms. I have provided a copy of the transcript, it's the second document I gave you, of the S230 Committee of Conference discussion transcribed from the video that has been posted on YouTube at the link that I need to provide you. I ask that LCAR and Legislative Council review that transcript as well as the video. Legislative Council Attorney Aaron Adler attended and participated directly in this discussion of the S230 Committee of Conference on May 6, 2016. Again, you might want to consult with Attorney Adler. Title 3 VSEA, Section 847, which governs the LCAR process, states in relevant part, under subsection B, parens B, the committee may object under this subsection if, 1, a proposed rule is beyond the authority of the agency, in this case, the Public Service Board. 2, a proposed rule is contrary to the intent of the legislature. There's a 3 and 4. I won't go over it, that's not my point. But I am asking that LCAR, based on what I provided to you, and after due consideration of that information, object to the PSB temporary sound standard rules on the basis provided under 3 VSA, Section 847, parent B, subsections 1- and 2, that the proposed rule is beyond the authority of the agency, and that the proposed rule is contrary to the intent of the legislature.
Any questions? Thank you.
Okay.
It's the pleasure of the committee on this. Representative Buxton.
I move to approve.
It is been moved to approve this rule. Is there any discussion? Senator Bennett.
Madam Chair, I distinctly recall the conversation on the Senate floor about this during our convened session to discuss the governor's veto. And I am very much concerned that this rule that's proposed goes beyond what the legislative intent was. Now, my understanding of sound is that it depends on several factors, from geography to topography to weather conditions. And I am looking at a proposal that has suddenly taken closed windows into account, where that was not what I understood to be the norm. That makes no sense to me, and it represents a relaxation as opposed to a more stringent requirement than what the legislature had intended. So I'm opposed to this rule as proposed and would ask that we defeat the motion.
Other comments? Representative Buxton.
Might we have the first witnesses respond to the senator's comments? I'd be interested in their response.
Do you want us to come up or do you?
Yes, please.
opportunity to address the comments and the concerns raised. I need to be a little careful in the way I frame my answer, because the question of enforcement of the CPGs and the windows open or closed language is currently being litigated before the board. And so I don't want to indicate any prejudgment of that litigation. The first thing I would note, none of the CPG conditions actually state a windows open or closed assumption. For example, the level CPG that Mr. Braden referenced states, petitioner shall construct and operate the proposed project so that the turbines emit no prominent discrete tones pursuant to ANSI standards at the receptor locations, and project-related sound levels at any existing surrounding residences do not exceed 45 dBA exterior LEQ 1 hour, or 30 dBA interior bedrooms LEQ 1 hour. So as you can see, there is not a specific statement in that CPG clarifying how to resolve this question. In cases where the board has a couple pending enforcement cases related to potential CPG violations of the standard that I referenced on a couple of these projects. In those cases, some of the developers have argued that the CPG only requires a windows closed assumption, that essentially interior means windows closed. It's, not open. There is one case so you point out that the board has not issued a final determination in any of those cases, and is still considering them. There is a hearing officer has issued a conclusion in one proceeding that is consistent with the requirements that were adopted in the rule that windows open should be assumed essentially during the summer months and partially open during the shoulder season in that proceeding. But in the other cases, and I should be clear again that was a hearing officer decision, the board has not determined, reached a final determination on that. In other cases, it is not clear. The level standard was represented, and I want to make sure there's a little complicated. Mr. Britt correctly noted the sound monitoring plan is not is required in the CPG condition. It isn't sort of spelled out in CPG conditions to contemplate sort of how you assess sound for ensuring compliance. As Mr. Griffin stated, there is a footnote in there that states that interior measurements shall be made with windows open and closed. The methodology for calculating a single attenuation value based on these measures shall be submitted to the board, department, and affected landowners for review prior to issuance of the monitoring report. So for background, this is in the instance where essentially there's reason to believe that at a residence, a project may have caused sound levels that are close to the standard. I believe it is well, I don't want to specify the decibel level because I don't have it right in front of me. But so if you get, within a couple decibels essentially of that, there's a process for doing individual attenuation testing at that residence. So you can say, you can take that outside level and make a conclusion as to what it is reasonable to conclude an interior level is. So that's what is the attenuation value. Now, that hasn't put into practice in this case, so that methodology is as of yet undefined. So there is not it does not explicitly assume that in certain periods it has to be windows open, as I think was earlier suggested. That said, there are other factors the board would need to consider when determining. The board did look at this case to consider that. So I think, from our perspective, this is arguably actually exceeds what may be required in some of those findings. But it's an undefined answer. It's hard to sort of precisely say on this question, but it may be. And I guess I'll leave it there.
I just have a follow-up. So as I read the CPGs, and says 30 dBA interior bedroom. Doesn't mention window one or the other. The board required King County Community Winds to submit a sound monitoring protocol, which you did, which I believe was approved. There's a footnote there that says interior measurements shall be made with windows open and closed. Is there a document that says what happens when you get an open window at any time of year and it's over 30? Is it clear that that is a violation in your mind, or is it not clear?
That is a very fair question. That is an answer that would be litigated before the board.
That's before the board.
It's not, that specific scenario is not necessarily, I don't want to put it into this. My point is, what I'm saying is that were those circumstances presented themselves, I would imagine that there would be disagreement as to how to resolve that question, and the board has not reached a determination in the case. So I don't want to prejudge what that determination might be.
Is that sort of the definition of arbitrary?
I'm not sure. What is the? I'm just wondering. I'm just trying to clarify what specifically you're referring to. Is the Windows Open standards the board adopted arbitrary question? I mean, I think the board. This is based on typical weather conditions. I mean, obviously, individual, homeowners may vary their treatment, but you have to have a universal standard of some kind, and so it's intended to capture likely use.
But the universal standard is testing with both the windows open and closed.
So that's
Not designating a specific time period of year and then deciding which will it be open or closed.
sure. So just to clarify, it is not. It is measuring with windows. So what's stated here is interior measurements shall be made with windows open and closed. But then the actual attenuation value applied to these measurements is, in these specific cases being referenced, is undefined.
Which puts you now in the position of making a policy choice, which is not your role. That's the legislature's role. And the concern I have with this rule is you have now established that policy in such a way that I understand is contrary to the intent of the legislature, where we left this building last trying to protect as much as possible individuals who may be affected, while at the same time preserving the ability for developers to have a true understanding of what their role was. And that's kind of the legislature's responsibility. Now, I happen to ride motorcycles. Every year I keep a record of when my last date of riding was and when my first date of riding was. My last date of riding in 2015 was December 26th. If I can ride a motorcycle on December 26th, the chances are pretty good that my windows are going to be open. First day was March 9th. Chances are pretty good my windows are going to be open. You've made a policy decision with this rule that is literally arbitrary and also overrides what we understood, at least from my perspective, when we left this building. So for that reason, Madam Chair, I'm coming back to say I'm concerned. I don't think we should pass this rule.
Are there other comments? Thank you. I'm sorry.
Question. So,
Yes.
was there any consideration taken into the loss of heat and energy when a window's open at a odd time? I mean, it seems to me, if you leave, I know my mother used to leave her window open all year until we convinced that, she was losing energy. Took a while, till she was about 97. But, I mean, of course, how do we take into consideration all the other foibles that might influence energy utilization? We don't have to answer that.
Just to be clear, that to the extent that this is a temporary rule, and I understand in the material that you provided us, and the memo, that there was a tight time frame. The legislature gave you a time frame. We asked you to promulgate some rules. You testified that they are as stringent, if not in your view, more stringent than the current practices. I also understand from some research that should any application come before your board, that you are able to create a more stringent, a tailored stringent sound standard for that particular project. These rules are only in effect until the 1st of next July, right?
Or until the board adopts the
Until
final
you
rule.
have a full rule. And I would assume, even though there wasn't real process to determine open windows, how you enforce that, and all the different pieces that policy disputes that we may have, that's going to have to happen before your final rule. I assume if the board is going to take a position one way or the other. Has anything I said been inaccurate, or am I being misled in any way? Coming to those conclusions?
I would agree with your statement that the board had a 45-day window to adopt these temporary rules. I would also agree that the board will be conducting a permanent sound rulemaking commencing in the very near future, and we have to adopt it by July 1st of next year or sooner if the board finishes its job before then. I would also agree that the temporary rule has great flexibility in it. We did establish standards for the small wind category and the large wind category. And following that, the board said we need flexibility to look at these on a case-by-case basis. And we reserve the right to impose different standards and lower standards as the cases come before us and as based on the evidence presented in those cases. So I think that's a real strength of the rule, that it's very flexible and the board can set lower standards if it finds that to be appropriate.
I applaud the ability to set more stringent standards on a case-by-case basis. And what I'm concerned about is that you have made an arbitrary decision based on whether a window is open or closed. I'm not going to pretend to be an expert, but I suppose there is a possibility that sound levels could be stronger under certain circumstances with a closed window as opposed to an open window. You have no way of knowing that because you, number one, haven't had the time to investigate those possibilities, nor have you had the experts come in and talk about those possibilities. So I'm a little concerned that when you have taken this step and imposed a policy standard, which is different than what I understood our intent was when we left this building. The excuse that this is only temporary in nature is no reason to step on this plane at all. In my eyes, Madam Chair, this temporary rule, if allowed to stand, is going to set a precedent for future determination. And that's not where we want to go with this language. If anything, we want to protect the individual as well as give the developer a clear standard by which to go by. And my understanding of our intent was we wanted sound measured at both the closed window and the open window situation. If you're limiting it on a year basis to certain months of the year for one or the other, that takes a step away and is potentially much less stringent than what we had originally anticipated.
So that's one assessment of something that is not a uniform assessment.
I'll just say one final thing, that I don't think it's arbitrary, having lived in Vermont my whole life, to determine that most people are going to have their windows closed in the winter months, and may have them open starting in March or April, and then potentially open in the summer months. So I don't buy the arbitrariness of that conclusion. I also acknowledge that the legislature's overriding intent when setting a 45-day deadline was to have a temporary rule, understanding that the science that sort of determine what your final rules would take more time, and that would take more analysis. But at the very least, whether they're perfect or not, our temporary rules, having some sort of predictability for developers to move forward in this interim period of time is in the interest of the state, and I think that's what the law says. Now be quiet.
May I say one more thing?
Is yours a question?
Well, I just want, none of this.
Okay.
Just to clarify, the standard remains no more than 45 at the exterior and no more than 30 at the exterior. The question...
Interior.
I'm sorry. I have to be careful. Yes. No more than 30 at the interior. The reference to the roll sound monitoring plan that said windows open and closed was the measurement protocol. It was not a change of the standard. The standard remains 30 at the interior. So whether someone's window is open or closed, the facility has to continue to meet that standard.
But by changing the protocols, which you're clearly doing here, you are essentially setting up the possibility of being less stringent. Because you're only measuring one at a time. You're not going to measure an open window in the shoulder months or winter time. Would you agree with that? The protocol as it now stands is that you measure both with the window open and with the window closed.
So,
Doesn't matter what time of year.
that is
That's
correct
the
on
current
the measurement. In terms of the question of whether you meet the standard, that is a different. I know, I understand it's very indirect.
We're parsing language, and I'm a lawyer too, so I know how to do that. The fact of the matter is, to reach the standard measurement, you have a protocol in place. The protocol, which is now our baseline, is that you measure both with the window open and with the window closed to make your standard determination measurement.
So if I can explain a little better the way the protocol lays out, that to highlight that distinction. The protocol requires you get a measurement of the outdoor noise. You would then need to adjust that by some attenuation value to reach a conclusion as to what the interior noise is under the protocol. The protocol requires you to measure both with windows open and windows closed, but it does not clarify how to combine those measurements in a way to find that attenuation value. So in terms of how you would apply those measurements is not spelled out specifically in the protocol. That's the reference. So it isn't to say that you would necessarily adjust it the same way. It's simply undefined.
Stating that the final rules would be proposed by the 1st of July, would be that's by the 1st of July next.
They would actually need to be implemented by the 1st of July.
Do we have an assurance from the Public Service Board where they're going to submit the final rules before the legislature reconvenes next year?
I'm not sure I follow
January.
That we are not going to submit final rules before January?
Correct.
So, I mean, we would,
Next 4 months.
the next rule would be an ordinary rule, so we'll need to go through the full rulemaking process. I don't believe at this point in time it would be possible to adopt a final rule before January, even if we submitted it in an initial draft tomorrow.
But even if it might be possible, we have your commitment that you're not going to do such a thing.
I will be brave and commit to not enact the impossible. I mean, I don't anticipate the board needs to conduct additional review, and a lot of these things are going to be fundamentally need more information on and need to understand better. So I don't see.
So when I read this today, you're telling us that there's no one's going to be surprised, but like such a huge by a proposed rule.
I mean, I'm not a board member, so I can't make their decisions for them, unfortunately. But again, I don't see a scenario that is likely to occur.
Yes, we can.
Yeah, I'm wondering why did you add the months, the presumption of windows open and closed at certain months?
Sure, because as I mentioned earlier, it has been, in prior proceedings, we have had developers object and say it should only be a windows closed assumption year-round. So the board concluded that in order to adopt a standard that was clear, and that made clear the expectations of what a developer needed to do, what would be in non-compliance, the board adopted a clarification of that it views as consistent with the standards it has previously adopted.
So the board,
Can I just ask a quick minute to leave? I'm supposed to leave 20 minutes ago. You said the developers, you did this, added the language because the developers wanted to know that it could be with the window shut, and they've been asking, hadn't some of the homeowners made the opposite request over the years?
Absolutely.
Okay, so without public testimony and without clear language in the legislature, you made the decision to write it the way the developers wanted, not the way the homeowners.
I don't think I would characterize this as the way.
No, probably not.
In fact, I believe some of the developers specifically submitted comments saying that the board should specify that it is only windows closed. So I would disagree.
You mean all year round? You mean all year round?
Year round, yes, absolutely.
are we ready for a vote? The motion on the floor from Representative Buxton is to approve the rule. All those in favor say aye.
Aye.
All those opposed say no.
No.
It passes 5-3. Rule is approved, this temporary rule. Thank you very much. Now, what is the pleasure of this